May I have your attention, please? I have a very brief and very pleasant duty, and that is to introduce your second co-chairman of this evening criminal law evening session for 1981. Michael Moldaver is somewhere around, sitting over in my left, has worked together with Brian Greenspan over the past 2 years, and this is the third year of these criminal law evening sessions CLE programming that we've offered. Now, just a word about Michael, which probably most of you know. He comes to us through the University of Toronto Arts and through the University of Toronto Law School, where he was a gold medalist in 1971, was called the bar in 1973, and since that time he has had, I should think I can say, the good fortune to practice in some form of association, and certainly over the past number of years in partnership with Ed Greenspan. Mike has lectured in the subject of criminal law widely. He has lectured at the University of Toronto Law School, the Osgoode Hall Law School of York University, and is an instructor in the bar admission course. He has worked in pretty well all of the criminal law associations which you might expect. As a past director of the Criminal Lawyers Association, a vice chairman of the Ontario Bar Association Criminal Law Section, member of the Advocate Society of the National Association of Criminal Defense Counsel, and has, as I said, co-chaired these programs for the Law Society. It's my pleasure to hand the program over to Mike, who will in turn introduce your panel for tonight.
Thank you very much, George, for the very kind words. And on behalf of Brian and myself and the Law Society, we wish to welcome you all to the second in the current evening criminal law sessions. I think we're in for a good night tonight. And without further ado, I think I should just start out and introduce the members of tonight's panel. I've always wanted to have the opportunity to introduce the guy who's moderating tonight. When we asked for curriculum vitae from the various panelists, everybody responded. Most were very humble, and I only received about one sheet of paper. Eddie provided me with the following file. It's about 300 pages. No, that's not true. All he really wanted me to say tonight was that he was my junior partner, that he practices a little bit of criminal law on the side, that he has done the odd homicide case in his career, but I'm not going to leave it at that because I feel that perhaps you should know a little bit more about Eddie. Personally, needless to say, we've been partners for a good number of years. I respect him enormously. He's a brilliant criminal lawyer in my view, and I'm sure in the view of most of you here. He graduated from Osgoode Hall in 1968 and was called to the bar in 1970. Since that time, of course, he has practiced exclusively in the field of criminal law. He has, since 1972, lectured at the University of Toronto, criminal law, lectured at Osgoode Hall in criminal procedure, and lectured at the bar admission course. He is the editor of just about every significant criminal volume that across the country. He's the associate editor of the Criminal Law Quarterly. From 1971 to 75, he was the associate editor of the Canadian Criminal Cases and is presently the editor-in-chief of the Canadian Criminal Cases. He has been the editor of Martin's Criminal Code since 1978. He edited the Criminal Appeal Rules, He is a member of just about every association going with respect to criminal law. And I can honestly say that it's been a pleasure and a privilege to be able to practice with Eddie as my partner for the years that we have. Now, if I can start perhaps on the extreme right, it's Dr. Fred Jaffe. Dr. Jaffe received his medical degree from McGill in 1944, and then in 1949 received a Master of Science degree in pathology. In 1951, he received his certificate in pathology from the Royal College of Physicians and Surgeons of Canada. He has held the following positions. He was an assistant pathologist at the Toronto Western Hospital from 1951 to 66, became the regional pathologist for the Department of the Attorney General of Ontario 1951 to 1972, and was also the medical director at the Centre of Forensic Sciences in the province of Ontario from 1966 to 1969. Presently, he is a director, Department of Laboratory Medicine at the Queensway General Hospital here in Toronto, and he is assistant professor of pathology at the University of Toronto, and he has written a number of articles in this area, as well as a book called A Guide to Pathological Evidence. On his right is Chief Justice Evans, disguised. Unfortunately, Chief Justice Evans is in London, and as I understand it, a jury is out on a murder trial there, and while he wanted to get back for this evening's lecture series, he unfortunately could not. Sitting where he would be, and we are obviously most grateful to him, I called him today at about noon hour, is Honor Judge Clare Lewis. Clare graduated with his LLB degree in 1963. He was called to the bar in 1965 and served under articles with Willard Z. Esty, QC, as he then was. From 1966 to 1974, his practice was primarily restricted to criminal defense work. 1975 to 1979, he became an assistant Crown Attorney for the Judicial District of York. In December of 1978, he was appointed Queen's Counsel, and in September of 1979 until the present, in February of 1979, he was appointed a judge of the Provincial Court, Criminal Division of Ontario. And he presently is very active, obviously, in that role, primarily at College Park. Clare has had a wealth of experience, both as a defense counsel and a Crown counsel. He has done a significant number of homicide cases, and I know that he will be a very excellent addition to tonight's panel. And again, we're most grateful to you, Clare, for filling in on such short notice. Beside Eddie, on Eddie's left, is Staff Inspector Wally Tyrrell. Wally joined the Etobicoke Police Force in 1954, and then he was promoted to detective in 1962. 1973, he became a detective sergeant, and the name was later changed to staff sergeant. In May of 1980, Wally was promoted to inspector, and presently holds the position of staff inspector as a result of another promotion which he obtained in August of 1980. Wally had about 8 years in the field in terms of various aspects of uniform duty. He spent 7 years in criminal intelligence, 10 years in terms of homicide investigation, and 1 year, the past year, has been involved heavily with administration. He has taken a significant number of courses since he became a police officer, 2 of which include courses in pathology and homicide investigation. And we're very grateful for Wally being able to attend tonight, and I'm sure he'll have some very interesting things to tell you about homicide investigation. Last but not least, on my immediate right is Chris Meinhardt. Chris graduated from Osgoode Hall Law School and was called to the bar in 1960. He was in private practice for a period of 9 years and then became Crown Attorney in 1969 and is presently Senior Crown Attorney for the Eastern Central Region of Ontario. That, ladies and gentlemen, is your panel for this evening.
Take a short recess for coffee after that lengthy introduction. Tonight we're going to talk about the prosecution and the defense of homicide cases. And the manner in which we will deal with the matter is to first begin with Staff Inspector Tyrrell to look at the investigation of the scene. I should say at the outset that it is not our intention today to discuss the recent developments in the substantive law with respect to self-defense or provocation, or for that matter to any case law in the area of homicide. It is meant to be a practical approach to the area of homicide investigations, commencing initially with the police investigation and dealing with the problems as all of us see them in the whole area of prosecuting and defending these cases. So I'll ask Staff Inspector Tyrrell to deal with the first series of questions on the investigation of the scene and what it is that police officers look for at the scene and what is the plan, if any, when the police arrive at the scene.
Gentlemen, number one in any police officer's mind when he attends an alleged homicide scene is preservation of life, number one, and I won't spend time on that because we don't have the time to go into every aspect of a homicide investigation here tonight. Ed mentioned the word plan, and really when a police officer or an investigator goes into a scene, he does have to have a plan. He has to go in there chronologically and examine that scene. It's extremely important because it always is not a homicide. It could be an accidental death, it could be a suicide, it could be death by natural causes, and all four of them, as I'm sure Dr. Jaffe would agree with me, on some occasions look like one of the other. An investigator, when he goes into a scene or the investigation of a homicide, there's basically three phases to that investigation. Number one being the scene, number two being the post-mortem examination of the deceased person, and then the investigation of the accused person. If I could just touch on the accused for a moment, sometimes defense counsel wonder why it takes us 4 or 5 hours to approach the accused and question him. We feel that it's only proper that we understand what we're facing before we question anyone, because in particularly a death in a home where there's a wife and a husband and a young child, and the young child is found dead, it would be very, very traumatic to either parent to intimate to them that they were responsible for the death when in fact they were not. So sometimes there's a great delay in talking to the accused person. I'll just pass on from that. The scene itself, the number one and most important thing at a scene is the protection, because every time a person enters a room or leaves a room, they take something in with them and they bring something out. Today with synthetic carpets, you could pick up a fiber in the hallway and take it into the room. With static electricity, you may also pick up something in that room and take it out on your shoes. So preservation and protection is very important. When an investigator gets a call, he does a lot of routine things on the way. He notes the weather conditions. It may not be important at the time, but it may be later. When he arrives, he notes the time of his arrival, a rough description of the premises as he enters, the persons who are present, the conditions of the doors, the windows, the lighting, and he also may ask the earlier officers that arrived how they found it, so that it's impressed in their mind, and he'll advise them to make notes of the way they found it. We, when we were speaking to young officers, recruits, senior investigators, even homicide course, where we speak to investigators, we tell them to make lots of notes, because you can't remember it all, especially 6 months down the road at a preliminary hearing, or perhaps a year to 18 months later at a trial. Lots of notes and lots of diagrams. The next thing before anyone does anything in the area of the scene is we contact the coroner and request his attendance at the scene. We have an identification officer attend, And before anybody enters the room, and that includes the coroner or the scene if it's an outdoor situation, the photographer takes photographs, and no one goes in until he does. Then the coroner will go in, make his brief examination of the body, give us what information he can at the time, leave us with a coroner's warrant so that we can later send this with the body to the coroner's building. And this, of course, is what the pathologist requires before he can make his postmortem examination. The Ident Bureau is then directed to take photographs of the entire scene, starting usually either clockwise or counterclockwise in the area of the scene so that he doesn't miss anything. Photographs overlapping. He would be also, him or his partner would be making a diagram, an overall diagram of the room so that he can put his photographs into chronological order. The investigator will be making diagrams, writing notes of the scene, questioning people that may be there at the scene to try and get a handle on the situation. And I'm going to be very brief in this. This is usually about an 8-hour lecture, and I'm going to skim over it, and if something comes up, maybe Ed would bring me back to it. It's very important in some cases that you bring a pathologist to the scene. I've had Dr. Jaffe at scenes in my early years in homicide, and if you get into a difficult situation, we need help. We call the pathologist to the scene. We also call people from the Center of Forensic Science, ballistic people. They help us many times with the direction the bullets were fired from. The firearm people from the lab, when they attend by examining the trajectory of casings, if it's an automatic weapon, can tell you approximately where the killer was standing at the time. We note the position of the body at the scene, arms, legs, clothing, the whole thing in its entirety, wounds that we see on the body that are visible at the time, location of any possible weapons in relation to the body, the condition of the person's clothing as far as whether it's wet, dry, the staining around the body, whether it's wet or dry, whether the blood has separated. You'll find the white and the red corpuscles separated in blood in certain conditions. This is all very helpful to the pathologist. The blood patterns, again, are very important to us. Blood, when it hits, if it comes off a weapon, will strike just like a stone skips on water. It will strike and then skip and leave a pattern. We can tell the direction the blood came from. Shell casings, as I mentioned, are very important to us as to where the person was standing when the shots were fired. Ed asked me to comment on photographs of footprints at scenes or fingerprints. Well, fingerprint examination, as you all know, is done with fingerprint powder. If it's on a dark background, they use a lighter silver or white powder. If it's on a light background, they'll use a dark powder. When it comes down to footprints, they will generally photograph them with a scale measurement in the photograph. If it's in soil and it's solid where they can get a cast, they will make a plaster cast of any footprints they find. One thing that you've probably all heard of if you have any interest in investigations of homicide is the value of cigarette butts. We always look for cigarette butts at scenes. It's important. You might find lipstick on it, might indicate that it was a woman. The smoker's blood type, the smoker's blood type can be established from cigarette butts. I can relate one case a few years ago at the Queen Street Mental Health Center. We found a lady at the back of a hospital. There was only 4 cigarette butts there and a whiskey bottle and a couple of cans, and they became very important pieces of evidence. The lady had laid there for some 16 hours, and it had rained during that 16-hour period, and yet when we took those cigarette butts to the lab, they still were able to establish that 2 were smoked by a person of A blood group and the other 2 by a person of O blood group. So their examination is very sensitive, as you must understand. After the scene is pretty well contained, we don't necessarily gather all the exhibits at that time. We try to cut that period as short as we can. We put a guard on the scene, and of course the building is held in our custody under the authority of the Coroner's Act until such times we're satisfied we've made all of the examinations that we feel are necessary. We later would come back and of course gather all of the exhibits, which might be shell casings, the weapon itself, could be hairs, fibers, cigarette butts, as I've mentioned, all kinds of things. Sometimes some forces also use identification officers for this purpose. The next step in our procedure is to go to the autopsy. We'll get the doctor out of bed sometimes in the middle of the night and have him come and do an examination. Again, we have a photographer present who photographs the body as it is before the doctor examines it. The doctor will make his external preliminary examination and as to the clothing and so on before it's removed, and then the clothing is removed, his further examination, and so on. And I'll leave a lot of that to the doctor. I'm sure he'll describe that in more detail. Identification of the deceased person is extremely important. You could have a case I mentioned earlier where you have a mother and a father and an infant, and the infant is found dead. We have to remember that somewhere down the road, if we use the mother and father for the identification of that child and it is a homicide, they may become the accused person. So we have to be careful with our identifications, and we usually use another relative who we know was not available at the scene and could not have caused the child's death to make the formal identification. There's many things done there: the seizure of the clothing, obtaining blood samples, urine samples, hair samples. In some cases it's necessary the doctor will take swabs and washings that are turned over to us. In ballistic cases it's necessary to perhaps take tissue from around the wound so that the ballistics people can examine this as to the distance the person was away when the shot was fired. We also make descriptive notes of the direction of the wound, the blows. In some blunt trauma injury, the doctor will be able to give us guidance as to whether the blow came from the right, the left, and so on. And again, I'll leave that for him to tell you how and why. And then finally, we'll then go and examine, or pardon me, go and question the accused person. And Ed has given me some guidelines what he would like me to mention, and I already have most of them because it's common practice for a homicide investigator. You note the man's condition as to sobriety, obvious mental illness, and so on. If you feel it's necessary, before or after interrogation, we take breath tests if necessary, and urine samples, which helps us as far as the consumption of alcohol or drugs. We note the condition of the clothing of the accused person, perhaps missing buttons, tears in the clothing, stains on his clothing which might appear to be blood, or on his shoes. The interview then would progress. Afterward, we would go into the seizure of samples from him if he wanted to give us samples, of course with his consent, such as the urine, sometimes blood samples if they will cooperate with us and give them to us. I've even had cases with Mr. Greenspan where he has recommended that the accused person give us these samples, and it's very helpful from both sides. Many times it's the thing that might make the difference between a murder and a manslaughter. We generally seize the clothing of the accused person. If it's a contact situation where there was a fight, we would seize the fingernail scrapings from the person, examine their hands, their arms, and their body in some cases for signs of violence. Another thing that Ed asked me about was the reenactment of the scene and photographing the reenacting of the scene, and in some cases this is done. Not in very many, but it has been helpful in some cases in the past. I believe you defended Mr. Hawley, did you not, Mr. Greenspan?
That's right. One of the practices that I wanted Wally to talk about was taking the accused back to the scene and photographing the accused as he reenacts the crime. That seems to be not all that common, but a practice that occurs in certain cases, and I wanted to find out for your benefit why that is done and whether it's been received in evidence in other cases.
It's not, as I said, it's not done in all cases, but sometimes what the accused is telling you doesn't really sometimes agree with your knowledge of the scene as you saw it. And we have taken accused people back. In one case I just mentioned a moment ago, the man reenacted the entire scene and described to the two homicide investigators how the whole thing happened, what he did, and so on. And he was photographed in various positions, pointing to things that had happened. That basically, and I'm trying to be as brief as I can because of the time area, is the approach that we take. From then, of course, we have the interviewing and the re-interviewing of witnesses and exhibits being prepared and packaged for the laboratory, preparation of the Crown brief, and of course, we're in attendance at the trials, reviewing the evidence with the witnesses before they testify.
Thanks, Wally. We'll come to deal with some of these questions as we go along, but Chris Meinhardt, I'd like to ask you, in your experience, given that this is a general outline or plan as to what homicide investigators do at a particular scene, what is your experience as to whether or not the defense takes advantage of this area, which is, in almost all homicide cases, the first series of witnesses that are dealt with are the people that attend the scene, the people that make the sketches, take the photographs, do the fingerprints. What has your experience been, and you've had a great deal of experience in homicide cases, as to what the defense does, and do they do an adequate job in dealing with this area?
Well, I wish I had done a great number of homicide cases. I really haven't. Some of the latest ones are presently under appeal, so I...
As well they should be.
hesitant about discussing them, but some things do come to mind. I guess I can sort of partially answer it. No, defense counsel do not take sufficient advantage of perhaps in some cases some slight shortcomings in the initial investigation. As you are perhaps some of you aware, in the smaller centers you may not have as much expertise brought to bear upon an occurrence as you would in a large urban center. If the issue in a case is self-defense, if the accused has been shot once in the head or in the chest or whatever, and no samples were taken for testing as samples of his skin or clothing, as the case may be, to determine whether there are any powder burns, which may assist in determining the distance. If your defense is that there was a struggle, then I would think you would bring forward that such items could have been tested, and since they have not, you perhaps have been deprived of evidence to show that your client really did defend himself rather than callously murder the victim. If, of course, in a given case, the deceased is found with 6 bullet holes in the back of his head, and if you are contemplating self-defense somehow, I don't think it would be as much assistance to you. If there is a killing which appears to be rape-related, and there were no swabs, vaginal swabs taken, which might have determined the blood grouping, at least in the A, B, O grouping of the accused, or whether or not he was a secretor. If that had not been done, then again, you could point out that had it been done, you're sure that that evidence would clearly establish that your client could not have been the person. Again, if the relevance of what was not done is marginal, then I think it really won't assist you to point out that someone has goofed, because you may be perceived as a rather petty and a vindictive person trying to make someone look bad. But if it's material, then I think you'll be derelict in your duty if you do not point it out. And it may certainly assist you a great deal. Now, if, on the other hand, perhaps the converse, if, as in one case, the defense was that the accused got the blood on his boots as a result of approaching the body later, rather than dealing with the body while it was still alive, and the scene discloses that there really was no blood around for him to step into, then you will be hurt by that kind of a defense. So it's important that you find out as soon as possible what the physical evidence of the scene was, what the forensic evidence is, and then use it to your best advantage.
Judge Lewis, you've had a great deal of experience, both as a defense lawyer and as a prosecutor. What's your experience about the way in which the defense either takes advantage or doesn't take advantage of this whole important area of the investigation of the scene?
Thank you, Eddie. May I open by saying that I had originally intended to, this evening, catch the 5 o'clock show at the Imperial, The First Deadly Sin, a novel which I much enjoyed, and I always understood that one of the, if not the first, at least one of the deadly sins was that of pride. For me to sit here in the stead of Chief Justice Evans is indeed an exercise in pride. I am not a little embarrassed to be in that position and feel entirely presumptuous. I hope that you will not be asking for your money back as a result. I am grateful for being here, and I would like to address myself to the issue of the preparation of the defense and the Crown with reference to the aspect of the scene of the crime as it applies to homicide cases. I feel that to a very large degree, counsel for the defense do not investigate either personally or with care through the Crown brief and so on, the evidence gathered at the scene, but I think also with respect that all too often is the case of Crown counsel. I can think of a case of my own involving the murder of a prostitute at Larry's Hideaway, one of our finer hotels known as the Prince Carlton, in which I was entirely fearful, while I personally believed it to be murder, that the jury would most probably return a verdict of manslaughter if I could make any verdict stick whatsoever, and I felt that would be entirely inappropriate. I knew how the defense would attack the case and what they would allege from the statements of the accused, and as prosecutor, I decided to impose on the homicide squad and have a view of the scene, and was struck, and I think the defense may find this as well, that the photographs which had been carefully taken, there was no suggestion of impropriety on the part of the police, the photographs simply did not reveal the size of the room, the location of the furniture in the room in a manner that was accurate. With the knowledge I had, having seen the room, I was able to successfully attack the position of the defense. And the verdict of murder was returned. Now, the court reporter has since committed suicide. There's no transcript, and I think he's got a pretty good chance at a new trial. But that's another matter.
Sure was suicide?
Well, I think so. Had Eddie Greenspan been the counsel and had the unlikely event been a verdict of murder, I might have suspected the verdict of suicide on the man. You know, I think the defense must always be aware of the issue of continuity of exhibits. While I'm of the view that it is greatly to the defense advantage to make admissions when one can do so with impunity, one can only make admissions when you are absolutely certain of your case and how your thrust is going to be presented. There are circumstances in which the continuity of the exhibits in a homicide case as in any other can be a critical issue, and you must know to a very fine degree the means by which the exhibits were collected. I think in terms of a drug case in which I handled in Cornwall, and you say, why drugs? The issue is opposite. My client, who's a very bright man now defended by Eddie Greenspan in the Supreme Court of Canada, kept maintaining that although the principal defense in this case was that he had been framed, and I believe it, nonetheless, I could break continuity of the drug. I didn't think so. But you know, you can assume that all police officers are not as able as Staff Inspector Tyrrell, and occasionally there are people who make serious errors. And indeed, in that case, the continuity of the drug was broken and the case failed at the close of the Crown's case. I know of a particular homicide case in which I was prosecutor. Sid Linden made a great deal out of the improper handling of the murder weapon, a knife. In fact, what happened is the uniformed officer first on the scene took the wrong knife. He just simply took the wrong knife. He misunderstood what the murder weapon was, and he preserved it beautifully for fingerprints. But what he did with the actual murder weapon was he pulled it out of a pail of water, and he stuck it into his Sam Brown belt, and he obliterated any prints that might have existed, and the issue of identity of the killer was very much alive. So no, I don't think that the defense, or for that matter, the Crown, are alive sufficiently to the importance of the evidence gathered at the scene. If you're a defense counsel, assume that the Crown isn't as prepared as you and prepare yourself. Unless it's Uri Priebus sitting there, and Uri will be prepared.
There are just some comments that I'd like to make about this as well. Oftentimes, the investigation of the scene is an area that is not fruitful to explore by way of cross-examination by the defense, but it doesn't mean that a defense counsel has to sit there for 2 days and say nothing while the Crown leads its evidence of sketch diagrams and photographs and a variety of things. It's my view that you start advancing your defense as soon as possible. In one case that I was involved in, the defense was self-defense. The accused position was that he was backed into a room by a man that was coming at him with a large Bowie knife, and he had no choice but to take the sawed-off shotgun that was in the washroom and shoot the man. He then ran away and was found later. There was a third person, an actual witness to the crime, who owned the apartment and was a close friend of the now deceased. The deceased did not die immediately and was alive when the police came and died later. The police examined the scene. They found the sawed-off shotgun under a couch in the living room, and they found no Bowie knife. So the case, although my client later in a statement to the police in his second statement remembered the Bowie knife. The first officer who testified was a person who took photographs of the scene, and he showed the photographs of the scene, and I stood up to cross-examine him. I had very little to say to him. His photographs were very nice, but I said to him, did you take a picture of a large Bowie knife somewhere in the vicinity of the washroom? And he said, no, I did not. And I said, well, did you examine the whole house to determine whether or not there was a Bowie knife there? And he said, I went through the house and I don't recall a Bowie knife. And I said, fine, thank you, I have no further questions, and walked away perplexed. Remember that the Crown has opened to the jury and has told the jury that this man was shot to death by my client who used a sawed-off shotgun. But I've now got in the jury's mind something about a Bowie knife that they didn't hear about in the Crown's opening. Second witness was the fingerprint examiner, and I picked up a Bowie knife that was sitting on my table, knowing that there is no Bowie knife found at the scene at all. Picked up a Bowie knife and walked over to him and held it up in a menacing fashion and said to him, tell me, sir, if somebody held a knife in this fashion, would it attract fingerprints? And he said yes. I said, thank you, no further questions. My ultimate defense, and I knew before I went in, my ultimate defense was that the person who was the tenant in that apartment, believing that his friend did not get, when he was shot, that it was not a fatal shot, hid the knife to protect his friend from being charged with attempt murder on my client, which was my theory, and ultimately successful. But the important, and there was no Bowie knife found at the scene. But the important thing is, now I told the jury that I bought the knife and made it very clear. But the important thing is that when you cannot possibly use the witnesses that are being called by the Crown, it doesn't preclude you from getting up and starting to develop your defense through them. The second point I want to make is this. In the trial that Michael had, my partner, he had a situation where his client, in what I thought was quite a preposterous story, but Michael got him acquitted after I decided I didn't want to have anything to do with the case. Wish I had kept it. But Michael had a situation where much depended upon his client convincing a jury or raising a doubt that there was a struggle. And one of the photographs that the police took was a photograph that showed a hallway and showed the runner in the hallway on the floor ruffled up against a corner. And so what Michael did was to cross-examine that person who was testifying as the photographs, highlighting and focusing in and highlighting on that specific point, that the runner was ruffled, which would indicate a struggle, and said to the officer, isn't it a fact that that runner being ruffled indicates a struggle? The officer says, I know what it indicates, but in the meantime, you've now told the jury that that photograph that you pass around to them that shows this ruffle indicates a struggle. So that later on, when your client gets on and says there's a struggle, he's merely corroborating what Michael already said to the jury that he drew with the inference from that photograph. The third thing is this, that I don't agree with Chris that you stay away from areas that necessarily are harmful. For instance, where there are 6 bullets in the back and your defense is self-defense. You can't leave the jury to sit with the fact that there are 6 bullets in the back for 1, 2, 3, 4, 5 days before you get around to get your client to understand and say, hey, look, it was self-defense. You have to do something to start presenting that defense to the jury. And therefore, you can put your theory to the various officers as to, well, for instance, if there are 6 bullets, the odds of them knowing which was the first and which was the last, or how long it took a semi-automatic to fire those bullets. And you have an obligation, I think, to take that witness and to put questions he can't possibly answer, that he won't know. He'll say, I don't know. So then you can say to him, so this could have been the first, and this could have been the second, and this could have been the third. You just don't know. To make your point to the jury that it's not just the obvious fact that there are 6 bullets in the back, and therefore obviously self-defense doesn't lie. So that is an area that I suspect defense counsel don't use sufficiently enough, namely presenting the theory through witnesses that may or may not be able to help you, but at least to get it before the jury, and secondly, to focus in on the one specific area in the investigation that matters a great deal. Now, Chris, one of the problems in this first part of the trial, of a homicide trial, is the presentation of what I will call, or what the courts call, inflammatory photographs. And since you're one of the leading experts in this province of leading inflammatory photographs, I thought it'd be useful to hear from you as to why you do it. And,
It's the Crown's Bowie knife.
Go ahead, Chris.
I was expecting a few more shots. But as far as if I just might digress, as far as the Bowie knife, one thing that you might think about, you should have some evidence of a Bowie knife later on, because if all that you have is brandishing of a Bowie knife that never comes up again, then it really gives the Crown something to go to the jury with and to discredit your defense. And I would very much like to have a case with Eddie where he is using self-defense with 6 bullets to the back of the head. But in any event, as far as photographs, I really don't think that a photograph can ever be termed inflammatory if it proves some issue in the case. I'll give you an example. There was a very brutal murder. The victim was a 9-year-old girl. She was kicked to death. And the accused defense, I already mentioned the case, it's my only case. His defense was that the blood in the boots was as a result of walking towards the body and walking around it after the girl was quite dead. Well, that put the quantity of blood at the scene in issue. There were photographs which we really didn't think we had a hope in hell of getting in. But as soon as the defense raised that issue, and they did it very, very early, in that case, I did not put anybody who took any photographs in early, because it was my belief that the defense would say that the blood on the boots arrived by some other means. And I was hoping that it would be that the accused approached the body sometime after the girl died and sometime before the authorities arrived. And that was done in cross-examination. Defense started putting its defense in very early. Well, then the officer who took the photographs went in, and I proceeded to tender these photographs. There was an objection. And of course, it was a lengthy argument, and the judge held, and on that issue he was upheld in the Court of Appeal, that since the quantity of blood at the scene was an issue, the photographs were really the best evidence to show that the only blood that existed in any quantity was under the child's head, and the only way that the accused could have gotten the blood on his boots was if he lifted the child's head and stomped in the puddle under the head. So when you are raising defenses based on what is found on the scene, bear in mind what doors that defense may open. As far as, of course, photographs generally, it is said quite often that if something can be described, a photograph does not really add anything to the evidence. From my standpoint, I couldn't disagree more. And whenever there is a murder that I'll be prosecuting, and there are photographs of the scene, including the body, then I will attempt to put them in. In some cases, if the defense, and it's far out, but I have had issue raised as to identity and the continuity of possession of the body, the best way for the Crown to prove identity is to have a photograph showing the face and more of the deceased, show it to a witness, is this the body that you found? Yes. And then later on during trial, on the issue of identity of this body, show it to someone who knew the deceased and say, who is this person? And you will have your answer. So when you're raising defenses, bear in mind that you may make things relevant, which if you did not raise, perhaps as sort of a tenuous defense, may not be relevant. I suppose photographs, just for the sake of showing how grisly the murder scene was, there is a good argument that they will add little to the case. But if the photographs, however grisly they may be, tend to illustrate or to prove something in issue, they're not inflammatory, they are relevant and admissible evidence. I appreciate, and if I was a defense counsel, of course I would try and sanitize the proceeding as much as possible. But when you're dealing with homicide, there's nothing really very sanitary about it. And if you're going to present a case from the Crown side, then it is, I think, incumbent upon you to remind the jury that what they're dealing with is, in fact, a homicide.
Clare?
Well, with respect, Chris, try to follow what you're saying, and I have a sneaky suspicion there's something spurious in it. I understood you to say at one point that if you had pictures of the body, you always try to get them in. Isn't that what you said?
If there is something unusual about the manner that the body died,
Well, I don't think that's what you said. In any event, I know that as Crown Counsel, from time to time, I was capable of being inflammatory, waving the weapon around in front of the jury and so on, but I really generally tried to play pretty fair on the use of photographs. And I'm not at all sure that it can't rebound on a Crown if he goes too far in any event. There was a case I had involving Mike Moldaver, and I lost it. It was his first murder trial. Was I embarrassed? Justice was ultimately done. His client hanged himself some months later, but
When he got the bill.
in that case, I actually did introduce the photographs of the body because it was critical, and it truly was critical, to the manner in which the crime was committed. It went to the issue of my theory of the Crown, and it went to the issue of the theory of the defense. And really, both sides used it, and we just had to deal with the fact that there was a body lying in the pictures. It wasn't as grisly as some. You know, when I defended Rene Vaillancourt, I don't like to tell you only about my losses, but I seem to have learned more from my losses. A photograph was put forward by the Crown in that case of the dead body of P.C. Maitland. Now, that was a highly emotional case. Maitland was a fine officer with a fine family who was acting in the highest traditions of his office and acting most reasonably in the circumstances when he approached my client, Filthy McNasty, who was sitting in the box there, and my client shot him dead. The Crown tried, I felt, with no valid reason, to introduce the photograph of the body. Justice Donnelly agreed and excluded it at that time, but I guess he felt that he needed a little bit of inflammatory evidence before that jury, because since I had refused, I'd admitted a great many things in that case, but one that I did not admit was that P.C. Maitland was an officer in the execution of his duty, and that for very technical reasons which had to do with my perception of the new moratorium which would be coming to pass on capital punishment, and my view that I could stop the hanging in the event that I lost as I did. In any event, when Donnelly recognized, his lordship recognized what I was doing, that photograph went bang before the jury, purportedly to establish that the man who was wearing a uniform, the body wearing a uniform, was an officer in the execution of his duty. Hell, they had all sorts of other means of establishing it and called witnesses in that regard. They even filed his oath of office. Generally speaking, I do not like to see the Crown trying to inflame juries or courts, and I think they ought not to do it.
And Clare raised the Vaillancourt case, and he was much too modest when he said he was replacing Chief Justice Evans. Clare has a very special position in the history of criminal law in Canada, particularly in homicide cases. He's the last defense counsel to hear a judge pronounce a death sentence on his client.
You know, there's very little to say on sentence on capital murder.
I guess.
And I want to tell you, it's just as it is in the movies. I'll never forget the 1st of October, 9:01 p.m., 1973, as His Lordship imposed sentence of death. And really, the words are, I'm sure Staff Inspector Tyrrell has seen it many times, but I had not. And my God, it's ghastly.
Should have asked it to be served intermittently.
Yeah.
Wally?
One comment on the photographs, which we have had some success with, is where there is some relevant evidence surrounding the body, and there is an argument about it being too inflammatory, we have taken one copy of the negative and opaqued the body out, so that all you see is a white outline
Form of a body.
in the, but it's still not inflammatory in that respect. And if there's something relevant around the body, such as blood patterns, which are important, then we have had success in getting those in before the courts.
I think, though, that counsel really has an obligation to take a look at all the photographs that the Crown wants to produce to determine whether or not it comes within what Chris has defined as creating some real probative value in the sense that it does describe a relevant issue, because the mere fact that it is inflammatory does not make it inadmissible if it does go to an issue. And so that you have to weigh very carefully what you're going to make an issue in order to make sure that photographs are not presented. I'm very afraid of photographs of the deceased, and I don't like to see them go before the jury, and I try to avoid getting the Crown into a position where he can argue that only the picture can describe it. And oftentimes, even though the Crown argues that, a pathologist or some other witness can just as easily describe in words what the photograph shows without having to present the photograph.